State Hospital Commitment Compassionate Release. I can't hold it any longer. I could go potty.
Mr. Chairman, members, I'm happy to be here today to present our bill SB 955, which would ensure that state hospitals are eligible
Move the bill.
for compassionate release. Mr. Chairman, this bill would create a compassionate release program for patients. Patients who participate in this program would have to meet very specific criteria, including that they're no longer a risk to society, that they can't benefit from treatment, that they are not committed as sexually violent predators, that the DA and the court that committed them are involved in the decision making, and that the judge that committed them has final approval over their release. Once placed in the community, these people would be eligible for federal matching funds for their treatment. I would note that hundreds of patients could benefit from treatment in our state hospitals, but are now on a waiting list. We have a waiting list for the state hospital. And this bill would create an opportunity for the state hospitals to admit and treat patients who are waiting and can benefit from treatment rather than continue to deteriorate in their condition. At the same time, terminally ill patients who can't benefit from treatment could and would probably be, these are people that would be eligible for palliative care, would spend the remaining life with their family. The bill is supported by our staff that interact with the patients and other organizations. I request your aye vote. We have witnesses. Thank you.
Mr. Chair, committee members, Douglas Chiappetta on behalf of the Union of American Physicians and Dentists would ask me. We represent the physicians that are on the front line in seeing these patients. As Senator Bell referenced, this is mirrored along a law passed and signed into law 2 years ago for CDCR inmates. Essentially what we're asking here is that the law be extended to terminally ill patients who have less than 6 months to live under Department of State Hospital supervision. I would just like to note one disparity. Current law provides for compassionate release program for state prison inmates. This program allows for inmates who have 6 months or less to live, including those receiving treatment in Department of State hospitals, to be discharged for their time remaining with family. However, other DSH patients, such as those who are not guilty by reason of insanity or incompetent to stand trial, are not eligible for such compassionate release. We ask that you correct this disparity today and support this legislation. Thank you.
Mr. Chair and members, Kobe Pizzati with California Association of Psychiatric Technicians. We represent 3,500 direct level of care providers to the mentally ill patients inside the state hospitals. As you might have heard, these state hospitals are incredibly dangerous places. There was over 3,500 patient-on-patient assaults last year. This is not the type of environment for a terminally ill patient to live out their remaining days. We would believe that those remaining days should be best served with their families so they can have time with their loved ones. For that, we support the bill.
Thank you. Are there any witnesses in support?
Khalid Pasagai, California Public Defenders Association, in support.
Selena Pryor, SEIU Local 1000, in support.
Thank you.
Rebecca Gonzalez, National Association of Social Workers, California, chapter, in support.
Thank you.
Joshua Golka with the American Federation of State, County, and Municipal Employees, in support.
Thank you.
Maya Ingram with the ACLU of California, in support.
Thank you.
Dennis Cuevas Romero with the California Attorneys for Criminal Justice, in support.
Linda Warner with the California Catholic Conference, in support.
Thank you. Are there any witnesses in opposition?
Sean Hoffman with the California District Attorneys Association. We really appreciate the work that the author and his staff have done on this bill. I think it's a vast improvement over when it left the Senate. We have kind of one more thing that we're looking for, the implementation of regulations to kind of lay out how this all works. We would like to be included in, as one of the, the law enforcement and prosecutorial agencies should be consulted in the development of those regulations. We'd like that to be more explicit, but we think that the bill is certainly on the right track in making it mirror the process that presently exists for compassionate release for individuals who are committed to CDCR facilities. So we are technically still opposed, but moving in a very good direction.
Thank you.
Asha Harris on behalf of the California State Sheriff's Association. In opposition, we have looked over the amendments, and unfortunately we are still concerned that the bill does not contain a recommitment provision. Should a person's medical condition change after release, we want to make sure that they are able to be recommitted, and as a result of that, we remain in opposition. Thank you.
Okay. Thank you. Are there any other witnesses in opposition? Are there any questions from committee members? Yes, Mr. Lackey.
Yeah, just real quickly, I had the privilege of already hearing this in Health Committee, and the same question I think deserves to be presented and on the record. But we hear the reference that these folks will be considered no longer risks, and we need to just kind of, in a very general sense, kind of remind each other how that determination is made, that someone is no longer considered a risk, and that it clearly does not include sexually violent predators.
Yeah, that's right.
Okay.
I believe those safeguards in the legislation, and Mr. Lackey has addressed that question previously in Health, and we also reaffirmed that that would not be the case. Thank you.
Okay, thank you. Good enough. Any other questions? All right, you may close, Mr. Bell.
Thank you. I think I've addressed just about everybody's concerns on this bill. I think some of the procedural things we'll be happy to discuss with organizations that spoke in somewhat opposition, but I urge and I vote. I'd be happy to work with the groups on those issues. Thank you.
Okay. The chair is recommending an aye. Madam Secretary, call the roll.
SB 955, the motion is due past your appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Lackey? Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago?
Aye.
Santiago, aye.
That measure passes.
Thank you.
Mr. Glazier, SB 1389, item number 19.
Thank you, Mr. Chair and members. Nice to be here. Senate Bill 1389 will require the video or audio recording of custodial interrogations for any person suspected of homicide. The electronic recording of interrogations has provided an important documentation of facts in the pursuit of justice.
Move the bill.
Would you like me to continue? All right. And with that, I'd like to introduce three witnesses that are here to join me, and they can be brief given the support from the committee. Don Anders, the Deputy Chief of Police from San Jose. Eddie Lowry from, say again?
Beaumont, California.
Beaumont, right. And the group is called Exoneree?
The Innocence Project. I'm an exoneree.
An exoneree. There's Lucy. Lucy. Okay, here to answer questions. So if I haven't introduced someone, please introduce themselves.
You have 4 minutes. We work it out.
My name is Eddie Lowry. I was a young soldier in the United States Army when I was wrongfully convicted of a rape. After spending 10 years in prison and another 11 years on parole or registering as a sex offender, I finally proved my innocence with DNA testing and was exonerated and proven totally innocent of this crime. My conviction was based on a false confession to a crime I didn't commit. On the second day of my interrogation, I asked for a lawyer and was denied. The detectives fed me details of the crime and asked me things like, did you go into the kitchen? Did you pick up a knife? I just agreed to everything they said, and when I gave the wrong answers, they would supply me with the right one. Things would have been different. At my trial, the jury At my trial, all the jury knew was that the two detectives swore that I sat there and calmly and collectively gave them the intimate details that only the perpetrator knew. It was my word against their word. Things would have been different if the interrogation had been recorded. The judge and jury would have heard my request for a lawyer that was denied. They would have known that the detectives fed me the details of the crime. They would have heard me guessing at questions. I lost 21 years of my life during trying to clear my name, and the community lost its sense of safety because the real rapist, Daniel Brewer, went undetected until 2009 when DNA testing revealed that he was the perpetrator. These losses could have been prevented if my interrogation had been recorded. With the ability of low-cost devices, there is no reason not to do this. I know that this bill would only require recording interrogations of murder suspects, which would not have applied in my case, but at least it's a starting point. Passing this bill would be a giant step in reducing wrongful convictions. 25% of wrongful convictions involve false confessions. I hope you take into consideration passing this bill and improving our justice system. Thank you.
Thank you. Next witness.
Hello, my name is Don Anders, and I'm here to offer my full support for Senate Bill 1389. I'm a 32-year veteran of law enforcement, and I served in both the Monterey County Sheriff's Office and the San Jose Police Department. I served as Deputy Chief of Police in San Jose, and at one time or another had overall command of 3 of the 4 department bureaus, including the Bureau of Investigations. I've been a line officer, a supervisor, a commander, and an executive. I performed and oversaw criminal and administrative investigations on a full-time basis for approximately 14 years. At the San Jose Police Department, we had a policy of videotaping custodial interrogations during homicide investigations, so I understand firsthand how important and valuable this practice is. Frankly, I'm disappointed that this practice is not already being used by all law enforcement agencies in California. To be fair, many departments do already videotape interrogations of homicide suspects, but a legal mandate is needed to ensure that all departments follow this practice. I support videotaping of custodial interrogations in homicide cases because interrogation of a suspect is one of the most critical elements of a police homicide investigation. For justice to prevail, prosecutors, defense attorneys, judges, and juries must be as informed as possible, and videotaped interrogations allow them to be as close to the investigation process as possible, short of actually being there. Thank you.
Thank you. Any witnesses in support? Yes. Name and organization.
Khalif Asghai, California.
Go ahead.
Lucy Salcido Carter with the Northern California Innocence Project in strong support.
Thank you.
Khalif Asghai, California Public Defenders Association, a co-sponsor and strong support.
Micah Doctoroff on behalf of the ACLU of California. We're a proud co-sponsor and here in strong support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California in support.
Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice, proud co-sponsor of the bill and strong support.
Chair and members, Jonathan Feldman with the California Police Chiefs Association in support.
Glenn Backus for Ella Baker Center for Human Rights and Drug Policy Alliance in support.
I would also like to let the committee know that Alex Simpson, who is upstairs right now with the California Innocence Project, is also in strong support.
Thank you. Are there any witnesses in opposition? Sheriff.
Asha Harris on behalf of the California State Sheriff's Association in opposition. Unfortunately, this bill creates unnecessary hurdles to admit otherwise truthful statements. We believe that many of our confessions, they are, recorded they are already recorded, but also if they're unable to record, there shouldn't be this assumption that it is, coercive or anything in nature. And so because of that, we are opposed to this bill. Thank you.
Thank you. Are there any other witnesses in opposition? Are there any questions from committee members?
Thank you, Senator, for bringing this bill forward. I can't believe in this day and age that there wouldn't be somebody with a phone or some other device that could record, and I think it is just blatant that law enforcement would ever do an examination. I think it's a blatant disrespect of the law to do an examination without a recording. We've heard too many cases of people just being badgered until, in order to get out of there, they confess. So thank you again for bringing this bill forward.
You may.
Just a moment. I just have a real quick question. I just wanted to make sure, does this bill do anything to disallow the inclusion of spontaneous statements that a suspect may make during an encounter?
No, it allows for spontaneous statements. There are ample exceptions to the requirement of video recording or audio recording. It's really a great law. It also allows the person being interrogated to ask that they not be recorded. So there are ample exceptions, including one for those circumstances.
Thank you.
Thank you. You may
respectfully
conclude.
ask for an aye vote, Mr. Chair.
Thank you.
Thank you.
And the chair is recommending an aye vote. This is good. So I'm just going to say that. Madam Secretary, call the roll.
SB 1389, the motion is due pass to the Appropriations Committee. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Lackey? Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago? Santiago, aye.
That measure passes.
Thank you. Thank you all. Thank you.
And last but not least, Senator Ricardo Lara. That would be SB 1052, custodial interrogation juveniles.
Thank you, Mr. Chair. I will be brief, and thank you for your indulgence. SB 1052 will require youth under the age of 18 to consult with legal counsel before they waive their Miranda rights. SB 1042 provides guidance for courts in determining whether a youth's Miranda waiver was made in a voluntary, knowing, intelligent manner as required under existing law. We have amended the bill to clarify that the existing public safety exemption for when Miranda can be disregarded will not be changed by this bill as well. Currently in California, children, no matter what age, can waive their Miranda rights, and we all know that that is simply absurd. When law enforcement conducts custodial interrogations, they are required to recite basic constitutional rights to the individual known as Miranda rights to secure a waiver before proceeding. Under existing law, although existing law assures counsel for youth accused of crimes, it is not required law enforcement. It does not require law enforcement and courts to recognize that the youth are different from adult interrogations. Just to note, members, recently in an appellate court held that a 10-year-old boy made a voluntary, knowing, and intelligent waiver of his Miranda rights. When the police asked if he understood his Miranda rights, the boy responded, "Yes, that means that I have the right to stay calm." The California Supreme Court declined to review the lower case decision. Several justices disagreed, and in Justice Liu's dissenting statement, pointed out that many states have taken legislative action on this issue and suggest that it's time for California to provide additional protections for our youth as well, and this bill seeks to do that. I respectfully ask for your aye vote.
Thank you. 2 witnesses, 2 minutes. Or 3 witnesses, 4 minutes.
Thank you, Mr. Chairman. My name is Helen Contreras. I'm here in support of SB 1052 and ask for this committee's support. I am a single parent raising 2 girls and a boy. My son is a big-hearted child. He thinks of himself as a family protector. When he was little, he idolized police officers and wanted to be one when he grew up. One day, several years ago, while I was at the library reading books with my daughter, my son at the time was 13, in school, I got a call from the police saying that they had him at the station. I was shocked. He had never been in trouble before, and I had no idea why he was even there. I rushed to the station, and when I arrived, they asked me all kinds of questions, but refused to tell me what was going on. Later, I found out my son had been picked up from school around 1 in the afternoon, and I wasn't notified for hours. I had no idea that he wasn't in school. I didn't know that the police could take my child out of school without my knowledge or permission. I did not know that the police could interrogate a child for hours without a parent being present. But in California, this is allowed. Excuse me. My son had just turned 13. He was 4'9" and weighed under 100 pounds. Later, I learned that he was handcuffed to a chair and sobbed through parts of the questioning by the police, who accused him of murder. He repeatedly told them it wasn't me and that he had no idea what they were talking about. Although he asked over and over again for me, he wasn't allowed to see me for hours. He finally gave up. By the time I saw him, he already had confessed to a crime he did not commit. Crying, he described to me how they said that they had a lot of evidence against him, which wasn't true. And that he confessed and told them what they wanted to hear because he believed it would mean he would wouldn't get into much trouble. As it turns out, that day was just the beginning of our family's nightmare. He was convicted of murder and had no connection to. Based on the false confession he gave at the station that day. After years of court proceedings, it was finally overturned and dismissed. But by that time, my son had sat in jail for something he didn't do. I cannot begin to describe the effect, the trauma that this caused my family, my children, my girls, myself, my son. You know, prior to this, I would not have believed that someone could confess to a crime they did not commit. I know that research has shown children are much more likely than adults to give their constitutional rights and falsely confess to crimes. In recent years, we've all read that science shows young people are still developing both intellectually and emotionally. Kids have different mental capabilities than adults. They have less ability than adults to easily understand legal rights and what it means to give those rights up. I am a mother. I don't need research or science to tell me that children are different from adults. I believe our laws should treat them differently. The police read my son his Miranda rights, but he did not really understand them or what it meant to waive his rights. He is a smart kid. I have no doubt that he could have understood his rights, but he needs help doing so. That is why I support this bill. It would ensure that children have someone to explain their rights and make sure they understand. I ask you to support SB 1052. Thank you.
Thank you. 1 minute.
Thank you, Mr. Chair and committee members. My name is Rourke Stacy, and I'm an expert in juvenile delinquency law. I've represented hundreds of youth in both juvenile and adult court, and I've argued 2 seminal juvenile confession matters in the California Supreme Court. In addition, I'm also on the national training team of the International Association of Chiefs of Police, where I train law enforcement about interrogating youth. It's these experiences which lead me to support 1052. Miranda warnings were created in 1966 for adults. Children did not receive the right against self-incrimination until the following year. The Miranda warnings were created originally to be a preventative measure to counter the inherent coerciveness of the interrogation room and to put individuals on notice about their constitutional rights and the ramifications of waiving them. But if you don't understand the rights and you don't grasp them, the Miranda process and its protections for youth are meaningless. Miranda was not crafted for young or immature minds, and the last 50 years since Miranda have seen a wholesale import of adult Miranda principles being applied indiscriminately to youth, with little consideration of how developmentally different youth are from their adult counterparts. Even though youth have the same constitutional rights as adults, how we're employing Miranda towards children makes it practically meaningless for youth because they simply do not understand the warnings or the consequences of waiver. As a result, what we have in California is that youth are not getting the protections that the Constitution was meant to provide. And the only way to ensure that they do is that they understand their rights before they waive them. And this bill would do that. It would require counsel to explain the Miranda rights to youth before they waive them. and it would give guidance to courts in assessing statements to the police. The bill would not change laws allowing police to interrogate in an emergency, nor would it affect the vast majority of interactions that police already have with youth. It would provide a developmentally appropriate protection. For many of these reasons, I urge you all to have an aye vote on this very important bill.
Thank you. Witnesses in support, name and organization.
Dennis Cuevas Romero with the Hernandez Strategy Group on behalf of the California Attorneys for Criminal Justice, co-sponsor of the legislation. Strong support.
Rosa Akil with the Alliance for Boys and Men of Color in strong support.
Linda Warner with the California Catholic Conference in support.
Maureen Washburn with the Center on Juvenile and Criminal Justice in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California in support.
Ryan Lowe, Anti-Recidivism Coalition, strong support.
Francisco Martinez with the Youth Justice Coalition, strong support.
Juan Peña with the Youth Justice Coalition, and strong support because at 10 years old I was also investigated and questioned by law enforcement for more than 2 hours without my parents' consent.
Kim McGill from the Youth Justice Coalition. We're honored to be co-sponsors on this bill. Thank you.
Thank you.
Patricia Song with the Children's Defense Fund, California, in support.
Art Gonzalez with the Anti-Recidivism Coalition in strong support.
Tequila Ochoa, Anti-Recidivism Coalition, co-sponsors, strong support. Thank you.
Maritza Galvez, Youth Justice Coalition, co-sponsors of this bill in strong support.
Cecilia Chavez from Silicon Valley DBUC, and we're in strong support.
Veronica Haro, the Silicon Valley DBUC, strong support for this bill.
Hi, Emily Borg with Fathers and Families of San Joaquin, and we're in strong support of this bill.
Haley Lucero, Fathers and Families of San Joaquin, in strong support.
Raymond Aguilar from San Joaquin, Fathers and Families. I was a lifer. I just got out after doing 25 years. I've been out for 2 weeks. I was a juvenile, and I was illegally Mirandized. But I just been set free by the governor.
Thank you, sir.
Natalia Dollery with the Ella Baker Center for Human Rights in strong support.
Maya Fennell with Ella Baker Center for Human Rights in strong support.
Jennifer Kim, Ella Baker Center in strong support.
Maya Ingram, ACLU of California in support.
Elizabeth Calvin, honored to be a sponsor of this important bill, Human Rights Watch. Thanks.
Thank you.
Khalif Asghai, California Public Defenders Association, in strong support.
Thank you. Anyone in opposition? Good afternoon.
Good afternoon, Mr. Chair and members. Sean Hoffman with the California District Attorneys Association. Unfortunately, here in respectful opposition to SB 1052. We have concerns about the practical way that the bill would be implemented, and would also note that the U.S. Supreme Court in Fair v. Michael C. in 1979 acknowledged that juveniles already receive a more generous interpretation of Miranda rights, in that the court has to take into account juveniles' age, education, and immaturity when considering whether there's been a valid waiver of his or her Miranda rights. SB 1052 would expand those beyond what's constitutionally required to mandate a consultation between the youth and an attorney, a consultation that, incidentally, the juvenile is prohibited from waiving. Failure to follow this procedure would result in a host of sanctions, which would have the ultimate effect of undermining the credibility of any statements made by the juvenile, regardless of whether any actual coercion took place. So, for example, if an individual was arrested, properly Mirandized, he's being transported to the jail where he's going to be provided counsel to have this consultation, any statements made along the way that came after Miranda but prior to this, regardless of whether he was coerced or the officer said anything to him, would effectively be inadmissible. They would be admissible with a very, they would be prejudiced by the fact that they could be used as evidence because they were made after Miranda, before he met with counsel. that those indicate that this was somehow an involuntary statement or an untrue statement or a coerced statement, when we don't believe that actually would be the case. So, unless there were some way to ensure that, as soon as that person was taken into custody, there was an attorney there for them to consult with, there's going to be some gap during which you're going to have statements that may be made voluntarily that could be unfairly characterized at trial as being coerced or made under some sort of duress. So for those reasons, we're opposed.
Thank you.
Asha Harris on behalf of the California State Sheriff's Association in respectful opposition. Our concern comes with this will slow down the interview process altogether. Sometimes law enforcement really just wants to ask a kid a question. We'll get permission from the parents, and Miranda, of course, will be read. And so it's not even that we're trying to follow through and charge this person for the DA purposes. Rather, it just could be a simple, hey, do you know where this is or that is? And this will essentially prevent us from doing that and give us unnecessary hurdles of having to find counsel, secure counsel, just for a simple question. So for those reasons, we are opposed.
Yes.
And I just wanted to acknowledge we do appreciate the author's amendments that provided for an exigency circumstance. I think that improves the bill. Not quite to our liking completely, but it's a step in the right direction.
If you get that soundbite.
Yeah, no.
Sheriffs too.
It was involuntary.
Thank you. Are there any other witnesses in opposition? Are there any questions from committee members? Yes, Mr. Lackey.
Yeah, just real quickly. So if I understand correctly, according to the opposition, spontaneous statements would not be allowed or admissible under the provisions in this bill. Is that correct or not correct?
We can have our sponsor.
That's not correct. Spontaneous statements do not trigger Miranda. Miranda is clearly defined in case law. It requires 3 elements. It requires custody, it requires interrogation, and a state actor. Numerous cases have always upheld that spontaneous statements do not fall under Miranda, and as such, this bill would not affect any spontaneous statements made by youth.
Okay, I misstated what I meant to say. The example that he used, and I do appreciate that clarification because there may have been some misunderstanding there as well, but say that you invoke the Miranda, you give the advisement, doesn't waive the rights, and there's a time period in between where the person gives statements that are meaningful to the investigation and actually expose them to culpability. Those would not be admitted, correct?
Again, I think I'm not clear exactly on the example you're giving because, again, what you've just stated does not necessarily trigger Miranda, which is really what this bill is about. Any spontaneous statement made is considered a spontaneous statement.
Yeah, I'm not communicating very well, or there's a disconnect here. I'm saying there is custody, and because of that custody, and there is charges being alleged toward this particular person, they give the Miranda advisement, and the person does not waive their rights. They want to have representation, so they're not going to speak. However, and while they're transporting that person to the facility or to wherever, and all of a sudden that particular person just, without being asked any questions, starts to admit to wrongdoing, those would not be permissible under this bill if that actually took place. Am I correct on that?
I do not think so, and this is why. Yes, your example gives custody. Absolutely, it gives a state actor. What's missing is interrogation. And interrogation is defined by Rhode Island v. Innis as, questioning by law enforcement or its functional equivalent. And there's many cases where officers may have read Miranda, put somebody in the car, took them to the police station, didn't say anything, and someone made a statement in the back of the car, and that statement was entered into evidence. So you need all 3 to trigger Miranda, and this bill is really designed for all 3 of those things to happen.
Okay. Let me just make one last final statement, and then we'll move forward. I believe that the age of understanding Miranda rights is a valuable discussion. I think we need to have that discussion. But I think that this bill goes too far because it actually asserts that young people in the age of 17 do not understand the ramifications of the Miranda rights, and I think that's too broad. And I don't think that's reasonable, and for that reason, I won't be able to support it.
Thank you. Mr. Melendez.
Thank you. Mr. Hoffman, would you please expand to the question that Assemblyman Lackey just asked, or at least tell me if you agree with what the other witness said?
Sure. There were several questions asked, but I'll try and...
Okay. Well,
but I'll tell you this. I do agree with the other witness when it comes to spontaneous statements. I don't think that this applies to those. My example that I gave that I think Mr. Lackey was trying to convey was individual is taken into custody. They are Mirandized. I think under my example, they gave a they waived. While they're waiting for that waiver to be sort of consecrated by this meeting with the attorney, the officer may ask a question. The officer may make a statement that elicits some sort of a response that could be interpreted as an interrogation. That's kind of open to interpretation. In that situation, any statement made in between the time that Miranda was given and perhaps waived, which wouldn't be a valid waiver until after they've met with the attorney, anything in there is, effectively useless for us. If it's going to come in as evidence that that statement was somehow made involuntarily or is untrue, which may not necessarily be the case, but it would certainly be colored in that light at trial.
Okay. Mr. Quirk.
So, with all due respect to the member from Palmdale, I honestly believe there are plenty of 17-year-olds who really wouldn't understand anything about this process and probably not even the consequences of what they've done. We heard from the mother of a youth offender earlier. I'm going to support the bill, and thank you.
Any other questions? Okay. Is there a motion? Pick those two, Low and Santiago. You may close, Mr. Lara.
Thank you, Mr. Chair. I do appreciate the discussion and also understand Mr. Lackey's concerns. Just to point that the only consequence of the failure to comply with this bill will be that the courts will review the information taken with extra scrutiny. I wanted to be very clear about that as well. And at least 8 other states have provided additional protections for youth who are being interrogated: Illinois, Iowa, Montana, New Mexico, Colorado, Connecticut, Indiana, and Oklahoma. Again, the Supreme Court has ruled on multiple occasions that juveniles are different we have to provide them with greater protections, and this bill seeks to do that. I respectfully ask for your aye vote.
Thank you, Mr. Lara, for bringing this forward. The chair is going to recommend an aye. Madam Secretary, call the roll.
SB 1052, the motion is due pass to the Appropriations Committee. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, no. Lackey? Lackey, no. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago? Santiago, aye. That measure passes.
That measure passes.
Thank you, Mr. Chair, members.
I'll still wait for it. So let's get as much as it's done, not hold everybody here.
SB 139, item number 1. This measure was on call. Melendez?